Good evening, sir. Good evening, classmate. I'm Bin Simon B. RANOSA, and I'm going to discuss the Chapter 4, which is the Reformation of Instrument under Article 1359 to Article 1369. Before we tackle Article 1359, first I'm going to define what is Reformation. Reformation is a remedy by means of which a written instrument is amended or rectified so as to express or conform to the real agreement or intention of the parties. Meaning, nagkakaroon ng reformation kapag yung nakasulat sa contract ay magkaiba kaysa dun sa napagmitan ng minds ng both parties due to mistake, fraud, inequitable conduct, or accident. Ibig sabihin nito, babaguhin natin yung written instrument na nakasulat doon sa contract para ma-express sa contract yung real agreement or intention ng parties. Now, in Article 1359, when there having been a meeting of minds of the parties to the contract, their true intention is not expressed in the instrument purporting to embody the agreement. By reason of mistake, fraud, inequitable conduct, or accident, one of the parties may ask for the reformation of the instrument to end that such true intention may be expressed. Second paragraph. If mistake, fraud, inequitable conduct, or accident has prevented the meeting of minds of the parties, the proper remedy is not reformation of the instrument but annulment of the contract. Reason for reformation. Equity orders the reformation of the instrument in order that the intention of the contracting parties may be expressed. Ibig sabihin lang dito, kaya nagkakaroon tayo ng reformation kasi yung written instrument na nakasulat dun sa kontrata ay hindi nagpapakita ng intention ng contracting parties. Kaya nagkakaroon kasi ng reformation para ibahin yung written instrument para maitama yon at makita yung totoong agreement ng both parties. Next, requisite of reformation. In order that reformation may be availed of as a remedy, the following requisite must be present. Number 1, there is a meeting of minds of the parties to the contract. Dapat meron ng kasunduan na naganap between both parties doon sa contract. Next. In first paragraph, it deals with reformation of the instrument, while in second paragraph, it deals with the annulment of the contract. Ano yung pinagkaiba ng dalawa? Sa first paragraph, nagkaroon na ng meeting of minds between parties. Ibig sabihin, pareho na yung parties na nag-agree sa kasunduan. Kaso yung nakasulat sa written agreement nila ay magkaiba kaysa sa dun sa totoong napagmitan ng minds nila. Kaya ang remedy dito ay reformation para yung true intention and agreement ng both parties may be expressed. Sa second paragraph naman, wala talagang nangyari na meeting of minds dahil yung concept ng isang party is vitiated. Kaya yung remedy is annulment of the contract. Next slide. Number 2. The written instrument does not express the true agreement or intention of the parties. Ibig sabihin, yung written instrument na nakasulat sa contract ay magkaiba kaysa sa totoo na pagmitan ng minds between parties. Number 3. The failure to express the true intention is due to mistake, fraud, inequitable conduct, or accident. Ibig sabihin naman ito, kaya yung written instrument ay magkaiba kaysa sa pagmitan ng minds between parties ay dahil sa mistake, fraud, inequitable conduct, or accident. Number 4. The facts upon which relief by way of reformation of the instrument is sought are put in issue by the pleadings. And number 5. There is clear and convincing evidence which more than mere preponderance of evidence of the mistake, fraud, inequitable conduct, or accident. dito naman dapat merong basis or evidence na nagpapakita na dahil hindi na-express sa written instrument yung true intention or agreement ng parties ay dahil sa mistake, fraud, inequitable conduct, or accident. Next slide. Ultimate facts to be alleged and proved in action for reformation. Number 1. In an action for the reformation of an instrument, the complaint must allege the true agreement or intention of the parties and that the instrument to be reformed does not express such agreement or intention. Meaning, para magkaroon ng reformation, dapat yung complaint ay nagkiklaim ng agreement ng both parties at saka dapat yung instrument ay hindi nagpapakita ng agreement ng both parties. In the absence of such allegation, there is no cause of action stated. Hindi naman kasi function ng remedy na gumawa ng bagong agreement ng dalawang parties. Under the technical rules of law, establishing the true existing contract between the parties could not be enforced. Ang proper remedy lang dito is reformation of instrument so as to express the true agreement or intention of the parties. Next slide. Number 2, the onus probandi or kilala siya sa tawag na obligation to prove an allegation or burden of proof is upon the party who insists that the contract should be reformed because of its failure to express the true intention of the parties, because the presumption is that an instrument set out the true agreement of the party. Ang meaning dito, sinasabi dito na yung parties na nag-insist ng reformation of instrument ay dapat magbigay ng burden of proof or allegation na nagpapakita na yung instrument ay hindi siya nag-express ng true agreement at saka ng intention ng parties. Sinasabi rin dito na pwedeng hindi magkaroon ng reformation ng instrument kapag natapos na yung pagkatapos na mapirmahan ng both parties yung contract. Kasi yung isang party ay napagtanto niya na lugi pala siya dun sa agreement nila. Magkakaroon lang kasi ng reformation kapag yung agreement is shown to be so grossly unjust. Next. Admissibility of parole evidence to show the true intent. As a general rule, the court may not allow the introduction of parole evidence to show the real agreements of the party. Ano ba yung parole evidence? Ito yung written or verbal evidence. Whatever is not found in the text of agreement should thus be construed as excluded, waived, or abandoned. Dito kasi sa part na to, ang pinakabasihan nila ay yung written agreement kasi nagkaroon na ng na-sign na yun ng both parties. Ngayon, kung ano yung mga ebidensya na papakita nila ay pwedeng hindi tanggapin ng korte yon kasi iniiwasan nila na magkaroon ng contradicting terms doon sa written agreement. Next slide. The rule of courts provides evidence of written agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon, and there can be, between the parties and their successor in interest, no evidence of such terms other than the contents of the written agreement. Dito naman, once na na-finalize na yung written agreement between the parties, yung written agreement na yun ay naglalaman ng lahat ng terms and agreements ng parties. Kaya yung mga evidence like yung mga oral evidence na ipopresenta nila ay maaaring hindi natanggapin ng korte kasi nga yung written agreement ay na-finalize na. Next slide. However, a party may present evidence to modify, explain, or add to the terms of the written agreement if he puts in issue in his pleading. Letter A. an instinct ambiguity, mistake, or imperfection in the written agreement. Ibig sabihin, may mali or hindi clear yung pagkakasulat ng written agreement. Letter B. The failure of the written agreement expressed the true intent and agreements of the party thereto. Ibig sabihin, yung written agreement ay hindi nagpapakita ng true intention at saka agreement ng both parties. Kaya one of the parties lang. Letter C. The validity of the written instrument, or letter D. The existence of other terms agreed to the parties or their successor in interest after the execution of the written agreement. Meaning, kung meron pang ibang other terms na napag-agreean nila na hindi nasama dun sa written agreement. Next slide. The term agreement includes wills. The mistake contemplated as an exemption to the parole evidence rule is one which is a mistake mutual to the parties. The parole evidence rule forbids any addition to or contradiction of the terms of a written agreement by testimony purporting to show that at or before the signing thereof, other different terms were orally agreed upon by the parties. Ibig sabihin lang dito na once na nagkaroon kayo ng agreement, dapat pinag-iisipan mo siya ng mabuti. The parole evidence rule provides that once a written agreement are finalized, evidence from outside the written agreement is prohibited for purpose of changing the terms of the contract. Meaning yung mga oral evidence like yung mga nagko-contradict sa terms ng written agreement or kung may addition ba dun sa may terms ng contract ay maaaring hindi natanggapin once na meron na silang written agreement. If yung written agreement naman ay hindi malinaw at hindi talaga malalaman yung intention ng parties sa pamamagitan ng pagbabasa ng instrument, dun lang i-allow yung ibang evidence katulad nga nung sinabi ko kanina, yung mga mistake and imperfection of the written agreements, yung mga validity of the written agreement, etc. Next slide. But even when the terms of a contract purporting to be a pact to the retro sale or an absolute sale are not ambiguous, it should be construed as a mortgage or a loan when the circumstances surrounding its execution or its performance are not incompatible or inconsistent with the theory that it is a sale pursuant to Article 1602 and 1604 of the Civil Code. Ang pinaka may na-ideal niya lang dito ay ang nakalagay sa contract ay pact to the retro sale or an absolute sale, imbes na dapat mortgage lang siya or a loan. Itong naman na to, part na to, i-discuss ko siya sa Article 1365. Next. Illustrative Cases. Number 1. Verbal agreement binding vendee to allow repurchase by vendor was intended by the parties as part of the consideration of the written contract of absolute sale. Facts. An absolute deed of sale of several parcels of land was executed by S, the vendor, and B, the vendee. In an action by S to compel B to allow the repurchase of the property, S alleged that his verbal agreement with B binding the latter to execute another document giving him the right to redeem the property was the real inducement on this part in making the contract of absolute sale, and that B subsequently refused to put this right in writing. Ano ba yung issue sa case na to? Ang issue dito is, should S be allowed to present parole evidence of the verbal agreement? Ang sagot dito ay yes. This case is clearly established B's promise to give S a counter contract, which express S' right to redeem. Pero kung sakali naman sa case ng mutual mistake, the introduction of evidence na nagpapakita ng true intention ng parties is allowed. Pero sa case naman na to, yung evidence na nagpapakita ng verbal agreement that constitute a part of consideration ng written contract should not be allowed. Totoo na yung parole evidence has the effect of modifying the agreement. Pero hindi dahilan yon para i-prohibit ng court si B to live up to his contract in its entirety to prevent B to commit fraud. Next. Number 2. Written contract shows an independent contractorship, but employer-to-employee relationship is sought to be established. Facts. X and Y, who claim to be employees of C Corporation, sued C before the NLRC or yung National Labor Relations Commission for illegal dismissal. The contract between the parties designated as pending contract shows upon its text an independent contractorship. Ano naman ang issue sa part na to? Ang issue dito is, may X and Y adduce or cite evidence before the NLRC of external facts which might establish an employer-to-employee relationship? Ang sagot dito is no. Dahil yung NLRC ay walang jurisdiction over the case. However, si X and Y may sue or appeal formally sa proper court of first instance na ngayon ay kilala na sa Regional Trial Court. Para dito sila mag-aas ng reformation ng instrument that evidencing the contract or for its annulment or to secure a declaration that disregarding the pending contract. The actual juridical relationship between the parties is employer and employee. Next. What constitutes inequitable conduct? Inequitable conduct to warrant relief by way of reformation has been held to consist in doing acts or omitting to do acts which the court finds to be unconscionable or unfair or oppressive. Ang example nito ay number 1, taking advantage by one party of the other party's illiteracy. Kunyari na lang dito ay hindi marunong magsulat at magbasa yung other party pero tinake advantage pa yun no? Isa. Number 2, abusing confidence. Number 3, concealing what of right should have been disclosed. Number 4, drafting or having drafted an instrument contrary to the previous understanding of the parties and making the other party to believe the instrument other than it actually is. Or number 5, in taking advantage of a mistake of the other party, known or suspected at that time of the instrument. Dito naman sa number 4, yung ibig sabihin lang yan ay yung parang dinideceive mo yung other party tungkol dun sa instrument. Sa number 5 naman, tinake advantage ng other party yung pagkakamali ng isa hanggang sa dumating yung time ng execution ng instrument. Next. Reformation and annulment distinguish. Bale, itong first paragraph and second paragraph na yan ay na-discuss ko na siya doon sa pinaka first part ng article 1359. Didiscuss ko na lang dito yung third paragraph. Reformation and annulment are thus inconsistent with each other. While the first gave life to a contract upon a certain condition, the second involves a complete nullification of it. Ibig sabihin ko nga kasi dito yung kaya nagkakaroon ng reformation ay para makita sa contract yung true agreement and intention ng both parties. Bali parang binubuhay niya lang ulit yung contract dahil may mga written instrument na mali doon. Samantalang dito naman sa annulment, wala talagang meeting of minds na naganap sa both parties. Kaya ngayon, ang mangyayari dyan ay complete nullification. Next. Example. S sold this land to B. It was agreed that the sale will include all the improvements. However, the contract assigned by the parties states that the land is being sold, excluding the improvements thereon. In this case, the remedy is reformation dahil nagkaroon ng meeting of minds between the two. Pero, kung sakali man na si S ay binibenta yung land niya excluding the improvements and B was buying the land including the improvements, then there has been no meeting of minds and the remedy therefore is annulment. Reformation cannot be a remedy because either way it would not make the instrument express the real intention of the parties. Next. Article 1360 to Article 1361. Article 1360. The principles of the general law on the reformation of instrument are hereby adopted insofar as they are not in conflict with the provision of this code. Principle of the general law on reformation. In the case of conflict between the provision of the new civil code and the principles of the general law on reformation, the former prevail. The latter will only have supplementary effect. Meaning, the general law on reformation has supplementary effect. It will supplement the provisions under the civil code about the reformation. So, ayun nga, ina-adapt din natin yung general law on reformation. But then, in case of conflict between the two, ang mag-govern ay yung provision ng civil code. Next. Article 1361. When a mutual mistake of the parties causes the failure of the instrument to disclose their real agreement, said instrument may be reformed. Article 1361 provides a situation where there is a mutual mistake. Later on, madidiscuss natin yung situation where a mistake is unilateral under Article 1362 and Article 1363 as we proceed with our discussion. Dito sa Article 1361, dapat yung mistake ay mutual. Tapos, it must be a fact. So, hindi dapat mistake of law ang mangyayari. Kapag nagkaroon ng mutual mistake, it causes the failure of the instrument to disclose kung ano yung tunay na agreement ng parties. Then, kapag nangyari to, yung instrument may be reformed. Mutual mistake as basis for reformation. To justify reformation under this article, the following requisite must occur. First, the mistake must be of fact. For if it is one of the law, the remedy is annulment. Bali, itong number 1 ay na-discuss sa Article 1331 at saka sa 1334. Number 2, such mistake must be proved by clear and convincing evidence. Dapat meron tayong may papakita na clear at saka convincing evidence. Number 3, the mistake must be mutual, that is common to both parties to the instrument. Ibig sabihin dito, dapat merong mutual mistake sa pagitan ng dalawang parties. Number 4, the mistake must cause the failure of the instrument to express their true intention. Tulad nga na sinabi ko kanina, dapat yung written instrument ay hindi nagpapakita ng true intention or agreement ng parties. Next. Relief by way of reformation of the written agreement will not be granted unless the proof of mutual mistake is of clearest and most satisfactory character. The amount of evidence necessary to sustain a prayer for relief, where it is sought to fact in a document is always more than a mere preponderance of the evidence. Dito naman, magkakaroon lamang ng reformation ng written agreement if the proof of mutual mistake at malinaw at angkop sa written instrument. The amount of evidence is necessary to input or to prove the validity of the fact in a document. Next. Mistake on one side, ibig sabihin nagkamali isa, tapos isa naman ay nag-act ng fraud or inequitable conduct. Ang issue naman sa case na to is reformation is proper? Ang sagot dito is yes. Dito sa case na to, meron lang na simple mistake ang naganap sa pagdadraft ng documents ng sale. The reformation is proper because there has been a meeting of minds of the parties in the contract. Dito sa case na to, alam ng parties kung ano yung property na binenta or binili niya. Kaya kahit na iba yung nailagay sa deed of sale, ang dapat nilang sundin ay yung napagkasunduan nila verbally. Dito sa case na to, kahit na hindi na magkaroon ng reformation, ang dapat na lang gawin ni B at C ay pag-execute ng mutual deed of conveyance. Ano ba yung deeds of conveyance? Yung deeds of conveyance is a legal document na that used to transfer title of property. Next. Illustrative cases. Number 1. Mutual mistake was made in designating the property sold in written contract of sale. Facts. S sold to B lot number 5, which was erroneously designated as lot number 10 in the deed of sale. Subsequently, S sold to C lot number 10, which through mistake was designated as lot number 5 in the deed of sale. B and C occupied the lots respectively sold to them. Number 2. Endorsee on promissory note 6 reformation of instrument of guarantee in favor of maker on ground of mutual mistake by substituting endorsee for maker. Facts. M. The maker executed the promissory note in favor of P, the payee. S. Surety made the notation on the note obligating itself for value received to hold M harmless against loss for having discounted the note. P. Endorsed the note to B, the bank. After maturity of the note, demand was made by B on M, P, and S, all of whom refused to pay. M. Being insolvent, B now seeks the reformation of the instrument of guarantee upon the ground of mutual mistake by substituting B for M. The correspondence between the parties and the exhibit presented failed to disclose either an express or implied admission that S had executed the guarantee in question for the protection of B or the bank. Ang issue naman sa case na to is the reformation of the instrument justified? Ang sagot dito is no. Para ma-justify yung reformation, upon the ground of mistake, the concurrence of the requisite na nabanggit ay kinakailangan. Si B ay hindi siya nag-establish o nagpakita ng clear at convincing evidence na meron ngang mutual mistake na naganap. Kaya yung reformation ng instrument dito ay hindi justified. Yun lang. Next. Article 1362. If one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. Article 1362 deals with the situation that have unilateral mistake, where one party is mistaken regarding a word definition, term, or other measurement in a contract, and the other party acted fraudulently or inequitably. Dito naman sa unilateral mistake, kung sakali man na both parties ang nagkamali, kahit sino sa dalawang parties yung pwede mag-ask ng or mag-order ng reformation. Pero kapag unilateral mistake naman, ibig sabihin, nagkamali yung isa. Pero yung isa naman na party, hindi niya nalaman or hindi niya nakita na nagkamali pala tong isa. Ngayon, yung kung sino yung nagkamali, siya ang pwede mag-order ng reformation. Kasi yung other parties acts in perfect in good faith. Next is unilateral mistake as basis for reformation. Reformation is granted when the mistake is mutual. Clearly, a unilateral mistake in the making of an agreement of which the other party is entirely ignorant and to which he in no way contributes, he will not affect the agreement or afford ground for its reformation. In other words, a party to a contract cannot avoid it on the ground that he made a mistake, where there has been no misrepresentation. There is no ambiguity in the terms of the contract, and the other party has no notice of such mistake and acts in perfect in good faith. A unilateral mistake accompanied by the other facts may be sufficient. Mistake on one side, fraud or inequitable conduct on the other. Ibig sabihin, nagkamali yung isa, tapos isa naman ay nag-commit ng fraud or inequitable conduct. Under Article 1362, the right to ask for reformation is granted only to the party who was mistaken in good faith. Here, the mistake is not mutual. Ang ibig sabihin lang nito ay kapag yung isa nagkamali siya ng hindi niya sinasadya. Tapos, yung isa naman ay nag-commit ng fraud, lalo na nag-take advantage siya sa pagkakamali ng isa. Ngayon, kung sino yung nagkamali ng hindi sinasadya ay siya ang pwede mag-order ng reformation. Next, illustrative case. Condition of repurchase was fraudulently omitted by Bendy from deed of sale with pacto de retro. Next slide. Pax. S sold the parcel of land to B with the understanding that the sale was subject to S right to repurchase. Sa tulong daw ng lawyer, B had the deed prepared in English language na kung saan hindi familiar si S. Ngayon, yung deed ay hindi naka-include sa deed yung condition ng repurchase, which fact was known to B. Before S signed the deed, he inquired whether it contained said condition, and he was told by B that it was sufficient. S relied upon the statement of B as to the contents and effects of the deed. Later, when S demanded the reconveyance of the property, B refused on the ground that he was the absolute owner of the same. Ang issue dito is S entitled to reformation? Ang sagot dito ay yes. Dahil si S ay nagkamali in good faith. Tapos, yung conduct na ginawa ni B ay considered na fraud or unfair dealings na kung saan nagwawaran ng reformation ng instrument. Next slide. Article 1363 to 1365. Article 1363. When one party was mistaken and the other knew or believed that the instrument did not state the real agreement but concealed that fact from the former, the instrument may be reformed. And the concept in this article is quite similar to Article 1362. Dito naman, yung one of the party committed the mistake, then the mistake is unilateral. Tapos, yung other party naman, alam na nagkamali yung isa, pero Hindi niya sinabi or kinonceal niya yung fact na nagkamali yung other party. Sa case naman na to, the one who can ask for reformation is the party who acted in good faith. Next, concealment of mistake by other party. The remedy of reformation may be availed of only by the party who acted in good faith. The concealment of the mistake by the other party constitute fraud. Dito naman, sinasabi dito na yung ginawa ng other party ay pwedeng i-consider na fraud. Kasi, kinonceal niya yung fact na nagkamali yung isa. Ngayon, yung pwede lang mag-cause ng reformation ay yung party who acted in good faith. Next slide. Article 1364. When through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument or of the clerk or typist, the instrument does not express the true intention of the parties, the court may order that the instrument be reformed. In this article, neither of the parties is mistaken. Ibig sabihin, ang nagkamali dito sa part na to ay yung third person like clerk and typist. In this case, the court may order that the instrument be reformed. Next, ignorance etc. on part of third person. Under the above article, neither party is responsible for the mistake. Hence, either party may ask for reformation. Dito naman, ang ire-reform ng korte dito ay yung instrument lang, yung pinaka mismong written instrument. Example, nagkasundo na sa presyo yung plaintiff at saka yung defendant para sa construction ng building. Ibig sabihin, nagkaroon na ng meeting of minds between plaintiff and defendant. Ngayon, due to clerical error, ang nalagay na sign dun sa written instrument ay dollar sign imbis na peso sign. Dahil di naman mistake ng both parties yon. Either parties may ask for reformation of the written instrument. Next slide. Article 1365. If two parties agreed upon the mortgage or pledge of real or personal property, but the instrument states that the property is sold absolutely or with the right of repurchase, reformation of the instrument is proper. Sa Article 1365 naman, ang sinasabi dito ay yung dalawang parties ay nagkasundo sila sa mortgage or pledge. Pero, pagdating doon sa written instrument, ang nakasulat doon ay sale. So that in this case, the reformation of the instrument is proper. Next. Mortgage or pledge stated as a sale. Under this article, the reformation of the instrument is proper. Otherwise, the true intention of the parties would be frustrated. Such true intention must prevail for the contract must be complied with in good faith. Dito naman, ang gusto lang ng debtor dito is to secure the debt only. Isi-secure lang niya yung payment and debt niya through mortgage or pledge of property. Pero instrument na napirmahan niya is not a contract of mortgage, but contract of sale. Obviously, yung intention ng parties dito would be frustrated because of the written instrument. So, the remedy is reformation. Sinasabi rin dito na such true intention must prevail for the contract must be complied with in good faith. Next. When any of the circumstances enumerated in the law exist, an instrument purporting to be a sale with right of repurchase shall be presumed to be an equitable mortgage. Ano ba yung equitable mortgage? Yung equitable mortgage naman, although lacking in some formality, form, words, or other requisites demanded by statute. But it reveals the intention of the parties to charge real property as security for a debt, and contains nothing impossible or contrary to the law. Next. Article 1366 to 1367. Article 1366. There shall be no reformation in the following cases. Number 1. Simple donation inter vivos wherein no condition is imposed. Number 2, wills. And number 3 is when the real agreement is void. Bali itong Article 1363 at saka 1367 na to, i-discuss ko siya sa next slide. Article 1367. When one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. Next slide. Cases when reformation is not allowed. Ibig sabihin, ano yung mga cases na hindi pwedeng gamitan ng reformation. Number 1, simple donation inter vivos where no condition is imposed. Donation is an act of liberality whereby a person disposes gratuitously of a thing or right in favor of another who accept it. Ibig sabihin, yung donation is pagbibigay ng kusang loob o pagbibigay ng gamit ng wala kang hinihingi na kapalit. Kapag sinasabi natin na simple donation inter vivos, ibig sabihin nito, the donation shall takes effect during his lifetime. Kapag naman donation mortis causa, yung donation naman na to takes effect after the donor's death. Next. Letter A. In donation, the act is essentially gratuitous and the donee has therefore no cause for complaint. If in the deed of donation a mistake or defect has been committed, it is a mere failure in a bounty which, as a donor was not bound to make, he is not bound to correct. Of course, the donor may ask for the reformation of the deed of donation. Dito naman, sinasabi dito na kapag yung donation ay unconditional, bali, ibig sabihin na nagbibigay si donor ng bagay na bukay sa loob niya. Ngayon, si donee naman or yung pinagbigyan ay walang hindi siya pwede mag-complain dun sa bagay na binigay sa kanya. Syempre, nagmamagandang loob na lang si donor, tapos magrereklamo pa siya. Kung sakali man na magkaroon ng failure doon sa deed of donation, hindi nakasalanan ni donor. Pero kung gugustuhin man ni donor na magkaroon ng reformation sa deed of donation, pwede naman siya mag-ask ng reformation. Yun lang. Next. B. If the donation is conditional or is onerous in character, the deed may be reformed so that the true condition imposed by the donor or the real intention of the parties might be expressed. Dito naman sa part na to, kapag yung donation is conditional, yung donor pwede siya mag-ask ng reformation kapag yung deed of donation ay nagkaroon ng mistake, para yung real intention niya ay makita dun sa deed of donation. Number 2, wills. A will is an act whereby a person is permitted with the formalities prescribed by law to control to a certain degree the disposition of his estate to take effect after his death. Dito naman sa 2, wills. Alam naman natin na yung wills ay ito yung gustong ipamana ng testator bago siya mamatay. Kung paano hatiin yung ari-arian niya para sa mga anak niya, kunyari sa mga apo, ganon. Ngayon, dito naman sa wills, kapag namatay yung testator, nawawalan ng right of reformation. Furthermore, pwedeng i-revoke ni testator yung will bago siya mamatay. However, after the death of the testator, errors or imperfections in description may be corrected under yun ng Article 789. Pero hindi siya sa manner ng proper disposal of the property. Next. Number 3. Where the real agreement is void. If the real agreement is void, there is nothing to reform. Reformation would be useless because the real agreement being void, it is unenforceable. Technically, an agreement which is void is non-existent, meaning there's nothing to reform. Number 4. Ito naman yung sa Article 1367. Where one party has brought an action to enforce the instrument. Article 1367 is based on estoppel or ratification. When a party brings an action to enforce the contract, he admits its validity and that it expresses the true intention of the parties. The bringing of the action is thus inconsistent with reformation. There is no prohibition against joining in one action, the reformation of the instrument and its enforcement as reform. In estoppel, kung ano yun na yung na-establish ng parties through words or action, and other person has relied on this misinterpretation, ibig sabihin, parang kinonsider niya na yung yung sinabi ng or ginawa ng other parties ay tama pero mali naman talaga yon. Meaning, hindi na pwedeng i-deny yan. Article 1368 to 1369. Article 1368. Reformation may be ordered at the instance of either party or his successor in interest if the mistake was mutual. Otherwise, upon petition of the injured party or hers and assigned. Ibig sabihin, kapag yung mistake dito ay mutual, sino yung mga pwede lang mag-ask ng reformation o mag-order ng reformation of instrument? Next, party entitled to reformation. The above article enumerates the person who can bring an action to reform an instrument. Number 1, either of the parties. Katulad nga nung sinabi ko, kapag mutual yung mistake, pwedeng kahit sino sa dalawa yung mag-order ng reformation. Under siya ng Article 1361, 1364, and 1365. Number 2, in all other cases, the injured party, ibig sabihin, yung kung sino man yung injured party na siya lang ang pwede mag-ask ng reformation. Under siya ng Article 1362, 1363, 1364, and 1365. Number 3, the heirs or successor in interest in lieu of the party entitled. Ibig sabihin, kung sakali mang mamatay yung party na pwede mag-order ng reformation, ay kung sino yung heirs or successor na pinagkatiwalaan niya, siya yung pwede mag-order ng reformation ng instrument. The effect of reformation is retroactive from the time of the execution of the original instrument. So, it will go back to the time of the execution of the real agreement, not from the time when the instrument is reformed on the court. Next, Article 1369. Ito na yung last article na i-report. The procedure for the reformation of instrument shall be governed by by rules of court to be promulgated by the Supreme Court. Procedure for reformation. The rules of court govern procedure. However, the Supreme Court has not yet promulgated the procedure for the reformation of instrument. Dito, ang ibig sabihin ng nakalagay dito sa Article 1369, the burden of proof is on the party who insists that the instrument should be reformed. In short, ang magpapatunay ng true intention ng parties is yung party na nag-order ng reformation of instrument. There is presumption that the instrument expresses the true agreement of the party. So, kailangan ng party na nag-order ng reformation na i-overcome yung presumption na yon by presenting the evidence in proving the real intention or agreement of the instrument. That's all from my report. Thank you.